Alright guys, buckle up, because we're kicking this off with a guy whose rap sheet is so long, it shocks even courtroom. He's trying to explain that he wasn't evading arrest, just riding his bike home. But the judge? Not having it. With over 25 charges in his past, there's no sympathy left. The judge breaks him down, calling a problem, and makes it clear this isn't just a misunderstanding. It's a pattern. You can feel the exhaustion in the judge's voice. This isn't his first rodeo. This man is playing games, but court is not the playground.
Bennett?
1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, 20, now 21 cases. Just since 2020, possession 1 to 4, unauthorized use, possession 4 to 200, 21, evading arrest, felony theft, felony assault, felony possession of a controlled substance, possession of a controlled substance, possession of a controlled substance, now 24, possession of a controlled substance, possession of a controlled substance, assault, unauthorized absence from correctional facility, PCS, now 25, just in 25, PCS, unauthorized.
Next up, another repeat offender walks like it's just another day, but the judge reads him like a worn-out book. Burglary, resisting arrest, tampering, you name it, this guy's done it. And now he's asking for leniency? Not today. The judge straight up tells him he's dangerous and irresponsible. What's wild is how casually the defendant responds, like he's numb to the stakes. It's the perfect example of how court loses patience when you treat jail like a revolving door. Real consequences don't come with warnings anymore. They hit like a gavel.
Right use, and now you have an evading arrest.
A lot of those guys.
Stop! I didn't ask you to say anything. You missed court, and now you're here. If you ever miss court again, and let me tell you something, Mr. Price, I'm going to do everything in my power to protect my city at all costs. If I find that you are one iota of danger to it, it's really not.
Whoa, let's pause right here. This judge is not playing around. That warning about being an iota of danger? That's legalese for, you mess up again, you're toast. The charge? Evading arrest or detention. Up to a year behind bars. Or a $4,000 fine. What would you do if you were facing that choice? Jail time or a wallet hit? Drop your thoughts in the comments below.
Not going to go well for you. Do you understand me?
This one starts deceptively light. The judge says no probable cause, and for a second, it looks like the guy caught a break. But then, the judge hears about his open cases and warrants, and the vibe shifts instantly. That brief moment of relief, gone. The judge starts pressing, digging, and within minutes, bond is being questioned. This shows how fast things change in court once your history enters the chat. You might walk in smiling, but you'll walk out in cuffs if your past keeps catching up.
You're now charged with evading arrest or detention. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
Thank you, Judge.
On April 14th, 2025, in Harris County, Texas, an officer was patrolling the area of 999 Pasadena Boulevard, the Macroplaza Mall. The mall is closed during the early morning hours when this incident occurred, and no maintenance or cleaning personnel were on scene. 999 Pasadena Boulevard is near 1202 Pasadena Boulevard, which the officer knows from training and experience to be a high drug area. The officer observed the defendant standing near a mechanical box on the side of the main building of 999 Pasadena Boulevard. The defendant looked at the officer, who was in a marked patrol unit, and began walking toward his bicycle, which was laying on the ground nearby. Due to the above circumstances, as well as defendant's suspicious behavior, the officer initiated a subject stop on the defendant due to reasonable suspicion. The officer activated emergency traffic lights and began sounding the siren of a marked...
This is where things get real. The guy was on a bike, and the cops chase him down like it's a high-speed car chase? Standing on the seat to pedal faster? That's either Olympic-level cardio, or pure panic. But let's be honest, how many? If y'all think this sounds excessive for just being near a mall in a high drug area, let me know, because that's some profiling worth dissecting.
Patrol unit. The defendant continued to ride his bicycle away from the officer, standing up on the seat of his bicycle to accelerate faster. The defendant eventually fell off the bicycle and continued to evade on foot until he fell in the roadway of the 900 block of Pasadena Boulevard.
This woman pleads guilty to assaulting her child's father, but claims it was self-defense. She says he hit her first, and the bruises prove it. But the court doesn't deal in emotion. It deals in charges. The judge stays focused. Guilty is guilty. The sentence gets postponed, but her face says it all. She expected more understanding. This part shows how domestic disputes become legal nightmares, and how court rarely sees a full picture. There's pain behind her words, but law doesn't bend for heartbreak.
The defendant evaded the officer for approximately 736 feet.
The hell was he doing wrong? Riding a bicycle while white? He's not doing anything. Just presumptive police. No. Mr. Price, I'm going to find that there's no probable cause in your case today. We have enough death, dismemberment, and danger in our town as it is. Don't create any more. Be a good person. It's not hard. Get a job, do something with your life before something, or you end up with a 25-year sentence. It's lickety split. Something happens. Life is too short to end up in a 6x9 with a 25-year sentence. You know what I mean? Really. Please take a seat.
We've got a teenager in serious trouble here. He pointed a laser at flying aircraft, and now he's in front of a judge who's clearly not amused. The kid looks lost, like he doesn't understand the gravity of it. Deferred probation is granted, but it's conditional. Full-time job, no marijuana, strict check-ins. This is a second chance cloaked in a warning. The judge is basically saying, mess this up and you're done. It's not just a sentence. It's a fork in the road. The next move decides everything.
Good morning. Ma'am, you're charged with assault, causing bodily injury. You're facing up to a year in jail and or a $4,000 fine. You have worked out an agreement where they're offering you 3 days in jail with credit for the 1 day that you've done. You need to understand that you're making a lifetime decision today where this assault is going on your record and it will be there for the rest of your life. You can never take it off. From now on, you'll be facing a minimum of 90 days in jail for any new cases that you pick up. Do you understand?
I'm facing 90 days.
If you pick up any more cases,
Oh, yes, sir.
you'll be facing a minimum of 90 days in jail.
Yes, sir.
You're giving up the right to it. Is this on doctor? It's on doctor. You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization, you give up the right to appeal. Once you accept this agreement, you can never change this or undo this. Do you understand?
I do understand that.
This isn't like Target where you don't like it, oh man, this is hurting, you can return it. No, once you plead guilty, it stays with you forever, you never change it. If you're not guilty, don't plead guilty. It's just that simple, really, don't, because you'll always live with regret.
Sir, I was assaulted first.
I can't talk to you about that case. Right? You're telling me that it's self-defense,
A child a day?
Yeah.
She's gonna show up.
She won't. Excuse me. I'm happy to give you more time to discuss it. Just it's probably not best here. I live stream, so
Selling a stolen tailgate on Facebook? Yeah, this one gets messy fast. The woman claims she didn't know it was stolen, but the details are shady. She can't explain the buyer, the money, or this mysterious Javier. The judge isn't buying the story, and you can feel the tension rising every time she stalls. This is where digital hustling meets criminal exposure. What starts on Facebook Marketplace can end up as a felony real quick. Just because it's online doesn't mean it's off the radar. Thanks for watching. Don't forget to like this video and subscribe to the channel. We'll see you in the next one.
sure.
Okay, thank you, sir.
Morning, Mr. Tolentino.
Morning.
Sir, you're charged with illuminating an aircraft with a laser pointer. You're facing up to a year in jail and or a $4,000 fine. The agreement that you have worked out is a 6-month deferred adjudication. This is a very serious agreement that you're entering into now. This is a type of probation that if you complete successfully, you do not end up with a conviction on your record, but you cannot tell people it was dismissed. It doesn't get dismissed. You do a probation, complete it successfully, if you do, and you don't end up with a conviction. Do you understand the difference? You give up nearly every right known to man by entering into this agreement, telling us that you can complete this, and if you don't, you're facing an entire year in jail. Do you understand? You're giving up a lot of rights. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you accept this agreement, you are stuck with this until you complete it successfully or it gets revoked. If you do something to violate this agreement, like you pick up a new case, you don't do your class on time, you don't do your community service, I'm going to issue a warrant for your arrest, and we're going to have a hearing to see if you violated. If you do, you're looking an entire year. Do you understand? You still want to do this?
Yes, sir.
How do you plead to the illuminating an aircraft with a laser pointer improperly? Guilty or not guilty?
Guilty.
I'm not going to find you guilty. I'm going to withhold it for 6 months. You will do an effective decision-making class, thinking for a change, no drugs, alcohol, 25 hours of community service. Did you graduate from high school? Okay, what are you doing now?
Electrical. I do electrical.
Huh?
Yeah.
Okay. I want you to maintain full-time employment while you're on probation as well. I'll make you a deal. If you do well, you get everything done quick, I'll take you off in half the time. Meaning get your classes done, be nice to everybody. And if you do that, we can take you off in half the time as a reward. But if you mess up, it's not going to go well. Do you understand?
Sir.
All right, bud. Good luck to you, sir.
Thank you, Judge.
Thanks, John. Okay. Mr. Aguilar, you're charged with failure to stop and give information striking a highway fixture. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You're also charged with theft, a Class A misdemeanor where you're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Thank you, Your Honor. Law enforcement officer spoke with the complaining witness who stated that on April 2nd, 2025, he parked his truck in his company's parking lot, locked the truck, and when he returned the next day, his tailgate was missing. An employee of the complaining witness searched Facebook Marketplace and found a tailgate that matched the complaint.
And here's where we dive into one of the most gray area crimes out there, selling stolen goods, but claiming you didn't know they were stolen. Can you be charged for theft if you unknowingly resell stolen items? Short answer, yes, if they can prove you knew it was hot. And since the defendant literally told the officer he knew it was stolen, boom, that's what lawyers call a cell phone.
Witness's stolen tailgate and had recently been published. The law enforcement officer executed a sting operation to purchase the tailgate from the defendant, the seller, on Facebook Marketplace. He paid the defendant $140 for the tailgate. The defendant was subsequently arrested. The complaining witness stated the price to replace the tailgate was $1,117.65. The defendant stated he buys the tailgates from a friend for $75 and resells them for typically $300 to $400.
We have him taking the actual tailgate, right?
Yes, Your Honor, that's what it says. Well, it has him as the seller of the tailgate.
Yeah, I didn't take it, Your Honor.
Stop. Don't say anything. You have the right to remain silent. Exercise that right.
Yes, Your Honor, it has him as the seller and that it was recently published 2 hours ago on Facebook Marketplace. But those are the facts as far as the dim summary goes.
It says here that this defendant did then and there unlawfully appropriate by acquiring or otherwise exercising control over property, namely a tailgate owned by Jonathan Smith. Did he take the actual tailgate?
Your Honor, there are no facts alleged in the DEMS that he knowingly took the actual tailgate. However, the tailgate was in his possession and under his control.
Sure.
He was the seller on Facebook Marketplace. There's no information in the DEMS, though, that represents that he was the actual individual that stole the tailgate. In fact, when the officers interview him, he says that a friend, he buys the tailgates from a friend and then resells them on Facebook Marketplace.
Are we to assume that he knows that they're stolen? You know? He's charged with theft, right? It's a specific independent crime. So if he's selling stolen property, somehow there has to be evidence that he knows that it's stolen. How do we know that he knows it's stolen? We don't operate on hunches.
Your Honor, there is also an allegation, or it's alleged in the DEMS that the defendant told the law enforcement officer that he was aware the tailgate was stolen.
Well, there you go. Okay.
Thank you. It's my fault.
Mr. Aguilar, I'm going to find that there's sufficient probable cause to go forward in the theft case. What about the failure to stop and give information?
Failure to stop and give
Let's see. We need to do probable cause on that one as well, please.
Good, Your Honor.
Yep.
The law enforcement officer was following up on this case in the original report. The defendant's vehicle struck a metal gate at an apartment complex. A witness looked out her window and saw the suspect vehicle and photographed the driver and passenger as they exited the vehicle. Law enforcement officers ran the plates and had the vehicle and owner information. The law enforcement officer later observed the defendant's vehicle in front of the residence. The vehicle had significant damage to the hood. The law enforcement officer made contact with the driver, the defendant. The defendant was ID'd to be the vehicle owner. The defendant stated he loaned his vehicle to an acquaintance he only knows through Instagram. The defendant showed the law enforcement officer the man's Instagram named Go Get a Veil. The defendant claimed that this man needed to borrow the car to pick up a girl. The defendant stated he would obtain the man's real name and provide it to the law enforcement officer by the end of the day. The law enforcement officer was not contacted by the defendant again. The law enforcement officer took a still shot on his body-worn camera of the defendant during the conversation. The law enforcement officer later compared the photos and saw the defendant was the same as the photo from the reportee. The law enforcement officer attempted to contact the defendant and could not. The apartment complex's estimated damages are $2,000.
Got it. Mr. Aguilar, I'm going to find that there's sufficient probable cause to go forward on both of your cases. Can you tell me if he has a license to drive, please? Texas driver license.
John, can you check that on Aguilar?
Don't. I know that you are itching to say stuff. Don't. You have the right to remain silent. Exercise. I've got a bunch of DAs here. Whatever you say, they're going to use it against you. So just now's not the time to fight your case. You will have the opportunity to fight it. Just now's not the time. I want you to understand, Mr. Aguilar, I will do everything in my power to protect my city at all costs, including property. And if I find that you're a danger to my city, I'm going to lock you up and I'm going to make your bond so high, you'll have hair falling out.
Yes,
do
Your
you
Honor.
understand?
Yes, Your Honor. Tell Your Honor.
Tell me what time of night was, do we know the theft of the tailgate? Was it in the middle of the night?
So it was reported around 5 p.m. That's the only information we have, Your Honor.
Okay. I'm ordering you as a condition of your bond not to pick up any new cases, not to have any contact with the complaining witness in the theft case, not to go within 200 feet of where they live or where they work. Do not pick up any new cases. You are not allowed to drive unless you have a valid Texas driver license and liability insurance in your name, and that is also a bond condition. If I find that you're driving without car insurance, likewise, you will go to jail. That's it. If I end up revoking your bonds for one thing or the other, they're probably going to end up around 10, maybe 15,000. And if you don't have anyone to pony up that kind of money, you will be stuck like Chuck in there until this case is over. Do you understand?
Yes, sir.
Do you have the ability to hire a lawyer?
Yes, sir.
Okay, we are going to give you time to hire a lawyer. So I will have you go to Victoria, sign a reset. After that, I'm going to have you take a seat in the jury box while we get your bond conditions. We'll have you sign it. After that, you'll be free to go. Don't be a danger to my city. Do you understand me?
I understand.
Come on. Good morning, Mr. Chimayo.
Okay.
Good morning.
Good morning.
Charged with driving while intoxicated you're facing up to a year in jail and or a $4,000 fine. You have worked out an agreement where they're offering you 27 days in jail with credit for the 9 days that you have done. You need to understand that this charge from now on will go on your record. It will be there for the rest of your life. From now on, you're facing a minimum of 90 days for any new cases, at least with DWIs that you pick up. You ever get pulled over again, officers will see this DWI. If they roll up to your window and they smell alcohol, or if they smell dope, it's probably not going to go well for you. So I would never get into a car and drive if you've even had a sip of alcohol. Do you understand?
Yes.
You're giving up a lot of rights by entering into this agreement. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal, meaning once you plead guilty, this goes on your record and it will be there for the rest of your life. Is this what you want to do?
Yes.
Is it true or untrue that you had a .15 or above breath test?
¿Verdad o no verdad? True.
I find that it's true. I'm now going to sentence you to 27 days, give you credit for the 9 days that you've done. I'm going to suspend your license for 90 days. Do not drive until you get a license, and good luck to you, sir. Thanks.
Judge, I was appointed to this case about 8 days ago, Judge, and I don't believe his energy status has changed since then. Can we ask the court to waive the DPS fee? Thank you, Judge.
Okay. You did the clerk. Please.
Hello, Judge. Can you hear me? Yes, yes, I believe Ms. Park appeared, is my understanding.
Give me a second. Hold on. Let me just stop this. Okay, what?
Yes, so it's my understanding Ms. Parks earlier, but she's there now, Judge. And so Victoria asked me to
36 Park, she's set for trial and showed up at 1 o'clock.
Today is your trial setting, and you show up at 1 o'clock. Really?
I didn't start like those, but I got lost.
I'm sending you for a drug and alcohol test right now, and then I'm rolling your case until tomorrow. You must be back here tomorrow. You understand me?
Yes.
Please take a seat. Mr. Muhammad,
How you doing, sir?
you're charged with failure to comply with basically FSGI, leaving the scene of an accident without exchanging information. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. Okay.
Thank you, Your Honor. On March 22nd, 2025, in Harris County, Texas, the complaining witness went to the police station to make a report for someone that struck her vehicle and failed to stop and give information. On March 24th, 2025, the officer reviewed body-worn camera where the complaining witness stated that while she was at a soccer game, someone struck her parked vehicle. The complaining witness stated that another witness left a note, and that witness observed the defendant strike the complaining witness's vehicle and leave without stopping and giving information. The witness stated the defendant was the coach of the opposing soccer team. The complaining witness stated that they talked to the defendant, but the defendant has failed to provide their insurance information. The officer met with the witness who viewed the accident and administered a photo array. The officer observed vehicle damage from the defendant and the complaining witness consistent with complaining witness and witnesses' accounts of events. The officer observed text of the complaining witness communicating with the defendant. In those texts, the officer observed the defendant state he is responsible for the crash and he has no problem paying for the expenses out of pocket. The complaining witness obtained a written estimate of cost of repair to her vehicle of $1,975.78.
Okay. Mr. Muhammad, I'm going to find that there's sufficient probable cause to go forward with the case. Does he have a license? You are not allowed to drive unless you have a valid Texas driver license and liability insurance in your name.
He does, Judge.
I'm also ordering you not to go back to the soccer field. Do you understand? If I find that you pick up a new case, if you go back, I will revoke your bond, put you in jail, no more.
Judge, may I? Is there any way we just do no contact with this person? Because in this club soccer world, there's only like 2 to 3 fields that they play on. My daughter's played Albion, and there's only like 3 parks that they play out. So can we just...
to happen again. And
I understand. Can we do a no contact so that he's not around that person, because he's the head coach of the soccer team? And we're going to get this taken care of pretty quick. I think they agreed that if he pays restitution, they're fine with it.
how is it going to be possible if they're still playing soccer that it's going to...
I think he can avoid them. These parks are big. There's Dice, Zuby Park. Go ahead.
First of all, sir, I've never had contact with the woman who claimed these claims. That's one. Second of all, I never left the scene because I had to attend.
I'm not going to argue with...
No, of course, I understand.
We're not arguing the case.
Sir, sorry, yes. I'm just trying to clarify that there's no contact between me and the or whoever's making the complaint at this moment. I've never had contact with her in my life, so there's no reason for any non-contact going forward, as I said.
Before he's allowed to drive, I want proof that he's got liability insurance, and I don't want you to have contact with the complaining witness. If I find that you get into another accident, if you're a danger to my city, I'm going to lock you up. Do you understand, Mr. Maham? Okay.
Thank you, Judge.
All right, we need to put bond conditions. We need to show proof to pretrial that he's got insurance, and then we'll allow him to drive.
Thank you,
Yes, sir.
Good morning, Mr. Hissa. Good morning. Sir, you're charged with failure to stop and give information, which is leaving the scene of an accident without exchanging information. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Thank you, Your Honor. On March 26, 2025, in Harris County, Texas, an officer was dispatched to a vehicle accident. The complaining witness stated he was driving when he noticed the defendant was tailgating him in his truck. The complaining witness stated he brake checked the truck. The complaining witness stated he attempted to change lanes to let the defendant through. The complaining witness stated the truck went around him, got on the median, and then collided with the complaining witness's vehicle on the side. The complaining witness stated the defendant pulled ahead of him and turned to leave the scene. The complaining witness stated he followed the defendant and got in front of his truck to prevent him from leaving. The complaining witness and the defendant exited their vehicles. The complaining witness stated the defendant came up to his face and was yelling that the defendant was trying to find a good place to stop. The complaining witness stated the defendant got in his motor vehicle and left without providing his driver's license or insurance. The complaining witness stated he did not want to press charges. The complaining witness estimated damages to be $500. An officer ran the plate provided by the complaining witness. There was a driver's license attached to the plate. The officers ran the attached driver's license and got a return photo, and the complaining witness ID'd the defendant by this driver's license photo that the officer showed him.
Mr. Hissa, I'm going to find that there's sufficient probable cause to go forward with your case. Do you mind running his license, please?
Yes, Your
The city
Honor.
has a valid license. You are not allowed to drive unless you have a valid Texas driver license and liability insurance in your name. If I find that you drive without either, or if you pick up a new case, I will revoke your bond, put you in jail. No more PR bonds. Do you understand? Do you have the ability to hire a lawyer?
I think so. Yes.
Okay.
Yes.
We'll give you time. If you have any problems, just come back and talk, and then we can go further. If you need an appointed lawyer or anything, we can always have you fill out an application. So for now, I will have you go to Victoria, sign a reset. We will then have you take a seat in the jury box while I get your bond conditions ready. We'll have you sign it, and after that, you'll be free to go. All right? Please.